Okay. Good evening, everybody, and welcome to the in-person, for the first time in 15 months, Rhinebeck Zoning Board of Appeals meeting. And I just welcome everybody. It's nice to be back amongst people and not just Zooming, although that was great. I do want to just say a couple of things very quickly. Fred Cheekman helped us get through the Zoom time, and I just want to say thank you to him again. And he was just awesome. He was. So it was a very difficult time, and we got through this with his help. I also want to welcome a new board member who is to my right. And Richard, I'm going to do it, but I'll try my best. I'm going to butcher his name. I'm famous for doing that. So, Richard Kopashansky.
Nothing like that.
That's it. Oh my God, I did it. So that means the first time that I'll screw it up after that.
Yes.
You know, Tim Econopoly. It took me about 6 months to get your name right.
Yes.
So anyway, I'll say.
The good news is that after tonight,
That's right.
There you go. I like that.
But, you know, we need volunteers out there in Radio Land, and it's tough to get volunteers. And Richard stepped up, and we really appreciate it. I'm looking forward to it.
I was the only one they could get.
True. You didn't say no fast enough. So I just wanted to say that.
Thank you.
All right, well, let's get going here. The first part of the meeting here is to review the meeting minutes from the last meeting. And did everybody have a chance to look at the meeting minutes for June 16th that were circulated? I think there were some minor changes.
Yeah.
Any comments, concerns, questions? Nothing? Okay, I'll make a motion that we accept the meeting minutes as presented for June 16th, 2021. Do I have a second?
Second.
All right, all in favor?
Aye.
Aye. Opposed? Abstained? All right, passed. All right, the first, we don't have a whole lot on tonight, but the first matter, new matter we have before us is Ruby's Properties, and I think that's Mark?
Yes.
Mark Kaminsky?
Right.
Mark, you've been here once or twice before, so you know the drill.
Should we move this back?
Yeah, probably move it back over there, and hopefully you can get him. Just let us know if there's any issues. Okay. So, as you know, just tell the audience generally what you're proposing, and then we'll figure out if there's enough information that we can accept the application. If so, then obviously we set down a public hearing.
Okay. Is this on? You can hear me okay?
Should be on.
Yes.
Good evening. Mark Kaminsky. I'm here representing Ruby's 9G Properties LLC. It's actually, so it's the Ford dealership, which Ruby's recently purchased, formerly Rhinebeck Ford on New York State Route 9G. As you can see from the site plan, it's, excuse me, there's actually 2 parcels of land associated with this project. This is in both by previous subdivision. Total acreage, it's hard for me to see. The 2 parcels, this is a 3-acre parcel, and this is about a 5-acre parcel here. It's quite simply a simple sign application, hopefully, for just changing the one sign on the front of the building from Rhinebeck Ford to Ruby's Ford. And so I had actually presented, this was a portion of a previous application that was presented to this zoning board back in 2016. And I just looked at the resolution, so Scott was actually the only one that's still on the board. That was part of the previous application. So when it was Rhinebeck Ford, there were multiple items. At the time, we were going through site plan approval with the town planning board, and then also signage came up with regard to that application. So there was an application made to this board because the existing signage at that time in 2016 was greater than the allowable, which in this case is 30 square feet. And so at the time, in 2016, I believe the total sign area was 185 square feet for the total area. With this particular application, we're actually proposing a reduction. So the Ruby's Ford sign is actually 7 square feet less than what exists on the property now. And so then also associated with it is a sign permit to change from Rhinebeck Ford to Ruby's Ford. Site plan, applications, and details with regard to the sign have been submitted to this board for their consideration. But I'm just trying to keep it brief for the board. But it's basically application same as before back in 2006. That's the only change with this application is just changes to the
Questions, concerns? Anybody need some more information?
Is something like this, a lot of things are grandfathered in. I know things that I do. Is this grandfathered in that side?
I tried.
No, we tried. It's a change. I mean, there is, you do consider what you've done in the past to some degree as precedent. That's why Mark was, up there saying that we gave us 185 the last time, and we're asking for 7 less this time around.
Right.
And, so there is some,
Normally, when you make a change, you need to come into
Yeah.
compliance with the code at that time.
so, I mean, for my purposes, it's a pretty simple application, and I don't need any more information. Thank you for the thorough application, for the little.
I just have one
Any
question,
questions?
if you don't mind. Is there light inside those Rudy's letters?
No.
What's the material? Just generally.
Final. I have it here in the, let's see.
There's no lighting now, there's no like up lighting.
There's no lighting at all.
Okay, that's all I really
I don't have that.
concerned
Let
about.
me just see if I have.
Because that would be something, if there was, you might have some more questions.
If you were adding light.
Yes.
Well, no, but the materials are important because they, consider the characteristic of the neighborhood and all
So,
that.
So they're in the packet.
Yep, yes they are.
Is, one
Thank
other
you.
question for me, is the type the same size as far as the height, the pipe size?
It's actually, the height is the same, and obviously, the 7 square feet is the difference in the length of the letter.
No, it's like 4 letters less than Rhinebeck, and I think the room around it, being a graphic designer, just looks a lot better the way it is, so.
Well, watch out if you get any other ideas later on.
Okay, anybody else?
No, I don't.
All right, then, at this time, I'll make a motion that we accept the application as presented, and we set it down for a public hearing, which I believe is the August 18th, Chris, is that correct?
Yes.
Is that a time you can make?
Yes, it is.
Okay. And so I'd make that motion. Do I have a second? All right. All in favor? Aye. Opposed? Abstained? All right, approved. We'll see you here on the 18th, and we can do the public presentation.
Great, thank you very much.
Thank you, Mark. All right, just a little housekeeping.
Oh, you're going to do seeker and
Yeah.
referrals?
First thing is seeker, the
For what application?
request is, it is,
in opposition.
I just wonder what, 125, 37K
If it's
to
Ruby
A.
for Red Wing, not tonight, that's public hearing.
Okay.
And then I think can be
Oh, I'm
submitted
sorry.
in writing.
617-5C22, installation of a traffic control device for existing street, roads, and highways, and sign, installation of signs. Yeah, we've seen that before. So I make a motion that we deem this to be a type 2 action under seeker under 617.5C22. Do I have a second? Okay, all in favor? Aye. Opposed? Abstained? All right. And it looks like we need to have several referrals, obviously, to the planning board, and then the WAC. And Kim, why is that? Just because it was...
It's in the LWRP, so that's why I don't think there should be any issues, but that triggers it.
And Dutchess County Planning because it's on...
It's a non-residential area. Variance.
Okay. So we'll make those referrals. And we need a volunteer for the resolution, and I know somebody here who's very good at sign resolution. But, maybe somebody else might want to do
I'm going to be
it.
on vacation next week.
All right. Okay, well, that doesn't... Okay. All right, Catherine, I think...
I can't give you every sign.
You just become an expert at it.
Well, I know, I can follow.
You're good at that,
I
So,
need help.
all right. Yeah, Tim's done the last 3 signs. So he's gotten really good at it. So. All right, so that takes care of that. The second matter that's on, and this is new business, is Red Wing. Before I ask the applicant to come up and give a presentation, just, I know that this has been the subject of litigation in the past, this particular property, and I'm sure everybody here is going to have opinions, and probably well thought out opinions. We're not here to have opinions tonight that we have a public hearing, but when we have applications that are, say, controversial or that arouse people a bit, I just ask that you please be civil. You know, we're not, I like to say we're not Washington, D.C. or New York City or Albany or some other terrible places. We're civil here in Rhinebeck, okay? And I am going to request, and actually I kind of demand that we be civil. Everybody's going to get an opportunity to give their opinions, and everybody should be respectfully received, in my opinion. And that's the way we're running here. So I'm not threatening, I'm just saying that, you know, we've had these situations in the past. This may be a situation where folks having high emotions about this particular application, and please keep it civil. And this is especially really for the public hearing, which will come down the road perhaps in August. All right, so with that, first we have a recusal. I have to take care of that first. And Tim, if you want to express your...
I live abutting property to the subject property, so I think it's appropriate for me to recuse myself.
Okay. Thank you.
And I would-
And with all that said, if the applicant could come up. And if you could just go through and briefly tell, I assume most of the folks here, a lot of the folks here are interested in this application, a lot of folks. Okay, so again, you'll get your opportunity to ask questions at the public hearing. The purpose here tonight is just to go over the application, to make sure there's sufficient information so that we can consider it. Assuming that is so, we will have the public hearing, and that'll probably happen on August 18th. So please, if you could just explain to us and to the public what you want.
Thank you, Mr. Bergen, and I just want to tell you that I moved from Albany, and now I live in Saratoga, so I was not
Okay.
I agree. Good evening, my name is Ryan Kelleher. I'm at Bond, Schoeneck & King, the law firm for Red Wing Properties, and we're here on an appeal from a notice of violation and cease and desist that was served on my client on April 27th. And without going through each one of the sections, essentially what that cease and desist and notice of violation said was that the mine access road, as you'll see in red, the town is requiring them to have a special use permit and site plan evaluation before building that. And we're here today to obviously appeal that and present our argument that a site plan approval and a special use permit is not required. And this case, as Mr. Bergen alluded to, has a long history, it has a lot of facts. And nobody knows those facts better than Mr. Lyons and Ms. Garrison, who were involved in the earlier litigation. I'm not going to go through every single one of those facts because we'd be here for hours, literally. But I will go through some of the pertinent facts for this application and for your evaluation as a CBA and making your determination. So, as many of you know, as alluded to earlier, Red Wing is a sand and gravel mine that is located right here in Rhinebeck. They have 240 acres. 37 and a half of those are permitted to be mined on. And in 2009, the town adopted a new comprehensive plan that essentially outlined a mining overlay district. The mining overlay district essentially drew out the line as to where you could mine and where you couldn't. And in 2009, at that point in time, all of Red Wing's property was within the mining overlay district, which means they could mine there, they couldn't mine outside of it, but their entire property was within it. And at that point, they were mining their 37 and a half acres, and it came to a point where they needed to expand that mine. So they ended up in 2013 applying for an expansion of that special use permit in order to mine other areas on their property. And just a brief background on the nature of mining is, unlike some other land uses, in mining, you don't mine your entire property all at once. It's done in pieces. So in this case, 37 and a half acres were mined. They went through those 37 and a half acres and they had to expand it. So in order to do so, they have a permit through the DEC and they have a special use permit with the town of Rhinebeck. They needed to apply for a larger permit in order to expand that mining operation. Well, in response to that application for the enhancement of their special use permit, local law 2015 was accepted by the town, and essentially what that did, amongst other things, was redraw the mining overlay district. And it redrew it in a way that only Red Wing's 37 and a half acres, most of which had already been mined, was allowed to be mined. And anything outside that mining overlay district, which has now been shrunk significantly to only those areas that were already previously mined, could be mined, and you need a special use permit in order to do so. No special use permits were needed outside that mining overlay district because you couldn't mine that overlay district. So, as alluded to earlier, this went on for a long time. There was litigation that went on for years. It went through the town, it went through the CEO, it went through this CBA. It wasn't exactly the same makeup as it is today, but it went through the CBA and ultimately it ended up in the courts. And we ended up in Dutchess County Supreme Court, and this went all the way up to the appellate division of the second department, which I argued with Mr. Lyons in March 9th of this past year. And I remember that, Mr. Lyons, because it's the last time I had been in the court because of COVID. That person, or in person. I obviously had been through Zoom. And after that argument in front of the appellate division, Red Wing was successful. They won their appeal. And what did they win? Well, they won the vested right to mine the area outside their 37 and a half acres. So what exactly does that mean? Well, it means that even though that mining overlay district was drawn, and they had land outside of it, they did not need a special use permit to now mine that area. The courts have ruled that they can mine that area. They have a vested right to do so because of decades of efforts and money and applications and this, that, and the other thing that they've had to jump through in order to get to that point. So why do I bring up these facts? Why are these facts important? Well, these facts are important is because this mine access road, which Red Wing is now trying to build in order to enhance their property, in order to mine further, has now been required, or now the town's requiring a special use permit. But the mining overlay district, the reason why I bring that up is because you only need a special use permit to mine inside that mining overlay district. You don't need a special use permit outside the mining overlay district. And normally that's not a big deal because you can't mine outside the mining overlay district. That's why there is a mining overlay district. This case is a little unique. It's more unique than other sand and gravel operations around here. And the reason why it is because we have an appellate division decision that was challenged up to the Court of Appeals, and that motion for leave was denied, meaning this is a final decision, this is the decision, and Red Wing has a vested right to mine their property. Now, they don't have a vested right to mine the whole 240 acres, they have a vested right to mine 94 acres. 37 and a half of those acres are inclusive of that 94, and those are permitted already. So really, we're looking at somewhere around 54 acres of additional mining area. Now, if they don't need a special use permit to mine outside that area, and the court has ruled that they are allowed to mine outside that area, it's our position that we don't need a special use permit to build this mine access road. And again, I'd like to remind the ZBA here is that that doesn't mean that we can just start mining the whole 54 acres. We still have to go through the DEC. Those applications are in place. We're working with the DEC. But importantly, we have applied to build this road, the red line here, and the DEC has permitted us to do so. In fact, 2 permits exist, which are in our application as exhibits, that allow for this mine access road to be built. One is an amended permit, and then the other one is an incidental take permit with respect to turtles that are on the property, both of which specifically outline the fact that Red Wing can build this road. So it was to our surprise when we contacted the town supervisor to inform them of our rights to do so and that we were going to go ahead and do it, that a notice of violation did come down. And to be quite frank, we've been trying to work with the town to get this worked out. We're not there yet. We hope that will be successful, but up until that point, we have to move forward with this appeal. Now, I said I didn't want to go into a lot of the specific violations because pretty much all of them have to do with just the special use permit. But there is one in particular I just wanted to point out to the ZBA, and that is section 125-68NN, which requires a special use permit for major excavation and or tree cleaning, but not including uses defined and classified as extractive operations and soil mining. And it's our position, which we're very confident on, that this section absolutely does not apply. It should be dismissed immediately. This mine access road falls under the umbrella of an extractive operations and soil mining. It's clear in the law that building mine access roads and other things like this are mining activities, which the court, the appellate division of New York State, has ruled we have the right to do so. I know that my time is short here. Does anybody have any questions? Because there is a whole heck of a lot more that goes into this, but for the purposes of this and not to take up everybody's time tonight, that's pretty much my summary of what our position is.
And it's all set forth in your application.
That's correct.
So that was great, and I'm glad you kept it brief. I mean, the bottom line is you're relying on the appellate division decision to say that you don't need the special use permit.
Right, we're essentially relying on the fact that the mining overlay district says you don't need a special use permit outside that yellow line, which obviously the road is outside the yellow line. And the reason why the appellate division decision is so important is because normally you don't need a special use permit because you can't mine outside the mining overlay district. Well, in our case, the appellate division says Red Wing can mine outside that mining overlay district.
Has the roadway been, when you got the stop work order, did you stop or was it continued? Because just driving by, it looks like the road is already there.
Yeah, I have not been there, so I don't know exactly what has been done. What I do know that has not been done is there's no blacktop or anything like that, and it most certainly has not been connected to the road. And my client has informed me numerous times that we are willing to work with the town on all of that to make it acceptable for the town.
But has the work actually stopped, I guess is what I'm getting at. Because when I drove by, I was curious.
Right.
I drove by and it just looked like the road had been, at least the gravel's there and it's been greatly expanded and all that kind of stuff. So
He's probably the better person
If
to
you want to come up and state your name, we know who you are, but state your name.
I'm Frank Downey, the president of Red Wing. The road is complete. There's 6,000 feet of turtle fence has been installed. 2 turtle underpasses have been installed, as well as 13 wildlife passages in the fence. It's pretty much completed. We just have we're finishing up the pipes right now, the turtle underpasses. We'll be out of there by the end of the week. And then we're not doing a thing until we get this issue resolved. I don't even have the mining area cleared. So we're not going to be digging, there's not going to be trucks going in and out of there until we get this issue resolved.
And there's no blacktop.
There's no blacktop.
And it's
I would like to,
not connected
I
to.
would like to pave it. The permit requires me to pave the first 400 feet of the road, and I would like to do that as soon as I can. You know, that'll help everything because it'll keep us from tracking anything out onto the town road. And it'll be aesthetically much better too.
At the time you got the stop work order, had you gotten to the point that you're at now, or did you?
No, all we had done was cut a couple of trees. We cleared some trees right at the entrance. At that point, we really hadn't done much at all.
So I guess what I'm getting at is, despite the stop work order, you continued on doing.
Yes, our attorney advised us that.
I'm gonna jump in.
And
Yeah, we did file a notice of appeal right away, which is my understanding stays in the violations. So anything that occurred afterwards was based on mistake. But I think what's important is whatever occurred on his private land has not touched the town, city streets at all. And we're willing to work with the town to make sure that complies with all town codes and everything else. And I've spoken to Mr. Attorney Raplansky about this. We're in discussions right now.
board members.
Could you show me, just up here, it's a little bit hard to see the outline of the entire property.
And Frank might
I
be the better.
think I know where it is, but
Okay, this is the line all the way around here. Comes across over here.
It's a black line.
You see the black line there? Cuts over from there, over there, up from here.
okay.
This is White Schoolhouse Road right here.
And that yellow line is that mining overlay district that was referred to. And then the red is obviously.
And the access road that you use currently is that kind of light colored line that goes over to White Schoolhouse up above?
That is not our property. That was the previous access that
Oh, right,
that's
okay, so
blocked off.
that
And
goes over some,
yeah,
okay,
that hasn't been used in years, since about 2013.
okay.
But this road here was an existing farm road. That's been there for as long as I can remember, since the early 90s, and I'm sure it was there long before that.
Was that the one we used when we went out and did the site inspection?
It
Some
must have
time
been,
ago.
yeah. That's the only other access to the property.
Right. It was kind of wasn't much of a road, let's put it that way.
No, it's just a farm road.
It was just a farm road, yeah. But now it's gravelled and it's been expanded and
Yes.
all that kind of stuff.
Yeah, it's 25 to 30 feet wide, all the way.
Do you have photos of the road?
I can take some. I don't know if they
Okay, that would probably be helpful.
can. I know, I think Mr. Raplansky is asking about a site visit.
Yeah.
And that's fine. I'd like to accompany whoever goes out to that, so I can answer questions.
Well, we can do what we did the last time. I mean, I guess I was the only one here the last time around. And, you know, we met you guys out there, you took us around and
Right.
showed us around.
Right.
And we'll do the same thing.
That, we just talked to him about that. So we haven't gone any further than that discussion. But like I said, we're more than willing to accommodate and discuss.
I got nothing to hide, so.
So I have a question. So can you point out again what road you actually put in?
Well, it was an existing road.
So
It
you're
was
talking
an
about.
existing farm road right here.
Oh,
red
So
line.
that was an existing farm.
It was, it actually
That's the road
hugged,
we're talking
it
about.
actually hugged the corner. You see this light line right through there? That's the original road. And we brought it out further,
So,
more because of the wetland rules. You have to have setbacks from the wetland. And this whole area right in here is wet.
so the curb cut was already there is what you're saying?
There's no curb cut.
Yeah,
there's
no,
curb.
we're talking about,
This is a town road.
this was a couple of dirt,
Yeah.
you know, there was grass in between it. It
was
was,
already there.
you needed a 4x4 to get, I mean, it was advisable to have a 4x4.
Four-wheel drive.
Well, yeah.
You know, an SUV could drive through
Right, but a nice car you wouldn't bring back there.
that. You wouldn't
That
want
was
to
more
bring
like
it.
a track.
I don't think a Mini Cooper would make it through the
Space,
tracks. you know.
space for, one set of wheels.
Yeah.
So where is the existing mining going
There's no mining going on at this point, but this is the existing 37 and a half acre permitted area.
Because you can't use that access road
Right,
anymore.
right. But I am permitted to mine that area, and I'm permitted to dig a 9-acre lake right in this area right here. At some point, but like I said, I haven't even cleared, there's trees 15, 20 feet tall growing in there, and I've got to get that all cleared off and get the debris scraped off of it before I go in.
Yeah, and as I said earlier, even if we build this whole road and it's all approved, we still have to go through the same DEC hoops and, any comment period that anybody in Rhinebeck has for that DEC application. So all of that still has to go through. This is just the very, very beginning stages.
Why would you put in a 9-acre lake?
That was an interim plan because we were getting so much pushback on the expansion. We ran out of material. There's no material to mine here right now.
Right.
So a 9-acre lake was an interim plan to at least get us some material.
For digging out the lake.
Yes. 9 acres, 35 feet.
I'm sorry, but, so where's the expansion area?
It runs from the yellow lines right up into here, and then this, right there.
And that same road, if you decide to go there, that you're gonna be using the same road?
That's gonna be the access road.
So presently, it's just to get back to the yellow overlay?
Yes.
It accesses the current permitted area as well as the future, if that goes through.
How many trucks do you figure a day?
We figured 20 to 25 a day. It could be more, it could be less. A lot of times it depends on the weather. It's a rainy day, you don't
Yeah,
get
right.
much. If you get a project, you might have more, like a landfill closure or something, but there's not much of that going on anymore.
The materials you supplied were voluminous, and I appreciate them. I have enough here to consider the application, but what I wanted to do was ask our council, do you feel that there's enough in the application for us to consider it?
Yes.
And accept it and set for the public hearing?
Yes. I just have one other question. Is there a scale in an office
There's
that's been
nothing.
constructed?
There's nothing. All there is is a couple of posts and a cable, 100 feet into the driveway. The plan is to put in a scale in a scale house. Those will be the only structures on site, maybe a shed to keep some tools in and that sort of thing. But other than that, we're going to put in a portable screening plant and low profile, not a really big deal.
Thank you. Board members, any other questions, concerns? All right.
I do.
Okay.
Because I'm just thinking, on that road in, are there many neighbors that you will?
No, we own the house on this side of the road and the house on this side of the road. We own all this property here. There's no houses. There's a house across the street, and that gentleman is friendly with us. There's only one more house, and that gentleman also owns that property.
Where's White School? Is that?
That's White Schoolhouse Road right there.
That's it right there, okay.
Yeah.
They do have one neighbor who's a board member.
All right. Any other questions, concerns?
Just a question.
Okay.
Go ahead, Captain.
So which direction typically will trucks go? Do you
And
get
we'll
out?
go to the south, out to Bullshead Road, and out to 90. Typically.
They go both directions along that. They go either direction.
Along 90, yes, either north or south, mostly
Yeah.
south. I'd say 99% would be going south. Unless it's local deliveries.
How far is your entrance, the road entrance, from the entrance down White Schoolhouse Road to Slate Road?
That's, I guess about a mile or so. I haven't really clocked it. I can. Mile and a half.
So you don't think you'd come out to 308?
That's a lot longer, and the road tends to be a little narrower and more winding.
Access road, yeah, then is White Schoolhouse Road. So that give you an indication of the practicality.
That's just a bad entrance onto Silk Border because it's, you know, it's at the bottom of
But
that
he's actually
curve,
built a wide road.
bottom of the
That's
curve.
why
And
it's
then,
road.
you know,
That's why we don't
White
have any plans on
schoolhouse
turning
road
left there.
challenged in
Turn right.
terms of
When
taking it
you
size of
said
traffic.
that you might provide some photos of the road, could you also provide like an outline, probably when you submit it to the DEC, you have like what's outlined for that additional 9485?
Yeah, the town should have all of that because they reviewed the incidental take permit and the plans for the minor.
Yeah, if you could just, that way it can just be part of the ZBA record.
Okay.
Yeah, and the 94 acres actually is inclusive of the 37.
Right.
So it's actually only an additional 50.
Right,
And a lot
yeah,
of that is wetlands.
but it just would be helpful just to
Right.
kind of, for the board to have an outline and then you can
Of
have it
the
part
additional or something?
Yeah, wherever the non-conforming goes.
It'd be helpful for the public too.
Sure.
Thank you.
And anything else? Any questions? Yeah, I think we have everything we need, so I'm going to make a motion that we accept the application. Do I have a second? Okay. All in favor? Aye. Opposed? Abstentions? All right, we'll be back here on August 18th, and we'll do the same presentation, but the neighbors will be here, and everybody who's here, who's listened to this, and anybody else who wants to come. We encourage people to be here. We encourage people to voice their opinions and get to ask questions of the applicant. You know, that's what we're here for. So everybody can voice their opinion respectfully and get answers to questions that they have. And that's the purpose of August 18th. So we'll see everybody here back on August 18th. Yes, Catherine?
Will all the materials, a copy of all the materials that we have be available for people to come look at? Is that something we
We didn't have them available through Chris, I believe, right?
Extra copies? We wouldn't have extra copies on file, but
They're posted online, right?
they are, the electronic copies are posted online. And I can give electronic.
Okay, I just wanted to make sure that the public had access. If
Yes.
if it's posted online, I think that's fine.
Yeah, and they could always ask for it from me electronically as well, or if they wanted hard copies.
Okay.
So did everybody hear that, folks, that it's online, but if you have any questions, Chris is fantastic, and she can answer your questions and provide you with the information you need so that you can be prepared for the next meeting on the 18th. Okay.
Also, we would encourage members of the public who comment, if you can submit the core of your comments in writing as well. That helps the board, you know, helps create a record, and it also helps the board members remember what your comments were as when they come to the point of moving into their deliberations.
Thank you, I appreciate it.
Thank you very much. Thank you. Okay, next we have one public hearing. Oh, that's right, you're right, it's housekeeping.
No referrals.
There's no referrals, and under seeker, it's 617.5C37, an interpretation of an existing code, rule or regulation, that sounds right. So I make a motion that we deem this application to be a type 2 matter under 617.5C37, interpretation of an existing code, rule, or regulation. Do I have a second? All in favor? Aye. Opposed? All right. And again, no referrals, and I will volunteer for this one.
Usually for interpretations, sometimes you ask for lines. If you'd like to do it. that's
Oh, no.
fine.
You're going to be very calm.
Okay.
I'll read it.
Thank you.
You're okay.
Well, I'm not going to do it by myself.
I understand.
Yeah. All right. So public hearings, we just have one public hearing, and that's on the Baker matter. It's a continuation of the public hearing we had at the last meeting. So is there, oh, yeah, here. So if you just go over, again, just briefly, the application. And is anybody here for the Baker matter? All right. So once the applicant has had an opportunity to present, you will have an opportunity to ask questions, voice your concerns, whatever. What we do ask you to do is when you come up, just state your name, your address, and ask your questions, state your concerns, whatever. So, you're on.
Thank you. I'm Matt Town from Willingham Engineering, representing Jeff Baker, 1010 Route 308. Jeff would like to construct a single-family home on his property, relocate an existing single-family home onto the property further to the north. He'd also like to build a pole barn, which is agricultural building, and there are 2 area variances required. One, because the principal dwelling, his home, is right here, and the accessory structure is right there, which is closer to the road, the accessory structure. So that requires a variance. The other variance required involves the aggregate square footage of accessory structures, and that's the accessory dwelling unit, the attached garage, and an existing garage that's going to remain over here. So that's, I forget the total, it's greater, the total aggregate is greater than 1,500 square feet.
Right, I think it came to 3,690, and the variance required was 2,190, if I recall correctly. Is that right, Ken?
I think the proposed was 2,520, and the variance was 1,020.
That's right,
Okay.
that's right. Because there's an ag exemption for
Oh, you're right.
a pole barn,
Yes.
and then this is an ag building, an existing one right there. So we have conditional approval from the planning board. Hearing's been open, closed over there. We've submitted to the health department for the new septic system that's going to serve the relocated cottage. And there's going to be a new septic system for the primary dwelling as well. So we're still waiting for David Pearson, but soil results were really good. That should be pretty easy. So barring that, there's nothing else really going on.
And just two points, just for the record, Tim Allen Brook has joined back on the meeting for this. But we had asked the applicant, one of the reasons that the public hearing was continued is that we'd asked the applicant to provide rendering, just kind of consolidating the plans and then a rendering of the pole barn. So just want to show that those have been submitted. I don't know if you want to.
Yeah, yep. So if you recall last time, they were on 3 separate sheets, and it was kind of difficult to tell how everything connected. So this is the entire footprint of the primary residence. It's going to be 1 story, no basement, garage area, rec room, and bedrooms. So I think that's a bit easier to see there. If anyone has any questions on that.
And then us. Oh, sorry.
Well, that's on barn.
This is the pole barn that was also submitted.
Yeah, he wants to do board and batten, stained. So, and this is, I think it's about 500 feet from the road. And there's vegetation in between as well, but, so.
And just, I think you just skipped by, but you just show the existing cottage again, because that's the one that'll be moved, and this will be visible from the road.
Yeah, it's going to be about 400 feet from the road.
Right. But it's open between the road and the cottage, so that will face the road.
Correct.
Yeah.
So When you say or it says that the existing house will be relocated, are you actually going to pick it up and move it, so the footprint's not going to change or anything? It's just going to
Correct.
just put it on a new foundation?
That's right. Yeah. It's been done.
Oh, sure.
Yeah,
Yeah.
so-
You have no mines to worry about, or probably. Okay. Any questions from the public?
Yes.
Come on up. Yes, absolutely. Please state your name and your address, and then, well, I just sometimes people forget.
Lisa, 6 Daisy Lane. I am the neighbor of Mr. Baker, and I have many concerns. Not that Mr. Baker should not be granted the variance. Mr. Baker's variance should be granted upon the condition of his land that he has let various farmers take over his land. Having said that, unfortunately, you're not the gentleman to ask, and I've asked Mr. Baker directly, did he contractually enter into an agreement with this farmer, which means that there could be a contractual obligation that supersedes anything. It means that we could be stuck with this farmer. How large is the pole building? Is that the two overheads? The two overhead doors? How many square feet is the pole building?
If you could actually, just for the public hearing, if you could direct a comment back to the board.
Oh, okay, I'm sorry. I thought I was being
Well,
respectful. All right.
no, you are.
So-
You are.
Then we just ask that it's just
So
directed.
maybe it's better to do it this way, so I'm not being rude to anyone. So I'm trying to see how large the pole building is going to be. If it's the two overhead doors, if I may, these are pictures taken yesterday of Mr. Baker's land under the ad. There's absolutely no way all of this equipment is going to fit in a pole building, which is my biggest fear, that this footprint that's been allowed will continue to grow. This was taken yesterday, and I had it printed out.
If you want to submit them for the
I
record.
would like to, they were current, they were done yesterday.
Okay.
My position is, if Mr. Baker wants to do the variance and take the ag credit, there should be a 10-foot fence going along all of his property, because I don't want to see that. I don't think anybody entering into the town of Rhinebeck wants to see that. It's insulting, it's a hazard, it's depressing. You work hard, you keep your property in shape, and actually since the last hearing, there's been more equipment put on there. It's almost out of spite. So I am being respectful of the neighborhood and respectful of what Rhinebeck stands for. And I just request, if the variance is going to be granted, put the fence up. Now, I've spoken, as per your request, to go to the ZBA enforcement. And she said there's been an issue with that farmer, and that in fact it could be a good solution if the ZBA takes into consideration, if you're going to grant these variances, let them put the fence up. Because what happens is the equipment migrates from across the street to the next field. And it's a game of cat and mouse. It's exhausting. So those are my comments. And I'm not saying that the equipment has to be shiny and new, but I'm saying there's a difference between ag equipment and hoarding.
You can respond.
Okay. So per Mr. Baker, when he moves onto the property, his plan is to farm it himself. Currently, it's a tenant farmer from across the street, and that's all his equipment. Jeff's indicated it's going to be removed, and it's not going to be on the site like it is right now. And I'll just say, I mean, typically fencing, landscaping, that would be under the purview of the planning board, and they've looked at that, and there were no issues there. So just wanted to indicate that. Jeff has stated he's gonna clean the property. He's gonna get rid of that tenant farmer.
I'd like to make a comment. What kind of respect does he have for his neighbor and his land allowing that to happen for 2 years? Was it because he was denied something the first time? I mean, this is not somebody who's coming in and being neighborly and respectful. And I asked him directly, that tenant farmer, is there a contractual obligation? That is a very fair question, because if he's contractually obligated with him for the next 2 years, that means I have to look at that, and everybody else has to look at that for 2 years? Fair question. And I really, it's very simple. That size of that pole barn is never going to house that tenant farmer's equipment. It's never going to. So going back to the planning board, I did go to the planning board. They said you had to go back to the ZBA. And trust me, I don't want to bust anybody's chops. I really don't. I know that farmer. I had my own issues with that farmer. Live and let live, but be respectful. And Mr. Baker hasn't even picked up the phone to say, I'm sorry about the mess, or I intend to contain it. No, Lisa, we don't have a contractual obligation with him. It's like I feel like I have to come and fight for something that should be just done respectfully.
In the correspondence that I saw, I didn't really see a commitment to have all that equipment moved. I may have missed some. I saw I might farm, and if I do, if I farm myself, then the tenant farmer will no longer be there, and all of that's what we removed. But I didn't see any commitment.
Yeah, it was that email.
I think it was an equivocal.
Right, I hope to take over
I hope
farming
to.
activity on my property when I move there. Once I take over the farming, I have no need for the current tenant farmer, and all of his equipment will be removed.
I hope to.
Yeah.
I mean, I don't know, that sounds a bit problematic to me. I mean, I just, I hope to, oops, didn't work out.
It's easier if we have a commitment from him saying that that is going to occur.
Whether the guy farms the land or not, I don't care. It's a junkyard.
Right.
It's not a Ford tractor or a plow.
And it's in his best interest, actually, to have it look nice, and not have all that stuff there.
I agree.
And by the way, we're not killing the messenger. But these are the concerns that we have, and it's long-standing, and they're very legitimate concerns.
Yeah, I guess after the last meeting, I didn't quite get the message that you guys wanted something a little more substantial. I can go to Jeff and request that from him if that's what you're looking for. Or...
Well, we had asked for a statement from Mr. Baker, but when we looked at the email, we thought that's pretty much what was expected anyway. Just, I don't know how much, we weren't sure what else we could really ask for. So.
Right, and there are limits to our authority, and what are pervious and
Respectfully, when I went to the ZBA enforcer as the board had advised me, she said, go back to the ZBA and tell them that it's a good solution to put up a fence. It's a good, they say fences make happy neighbors.
Well, unfortunately, she's wrong about that, because in my opinion, attaching a condition like that is outside this board's jurisdiction.
It's absolutely awful.
There has to be, I agree, I think it's unsightly.
Yep.
I think that everything that Ms. Kusa says about what the state of affairs there is correct, but the issue is, from a board standpoint, okay, in order for the decision to be valid from a legal standpoint, there are two issues regarding what you're requesting. One is, under the law, if the zoning board of appeals attaches a condition to an approval of an area variance, there has to be a substantial nexus between the condition that's being imposed and the area variance that's being sought. So if there were to be litigation over this, the courts would be looking very hard and scrutinizing the connection between the condition of putting a fence up and the area variances that Mr. Baker has requested. And in my view, there really isn't a strong nexus in between the issues having to do with the appearance of the property and the area variances that he's requesting. The second issue is that farming is an activity that is regulated by the state. It's subject to the Agriculture and Markets Law, as the town has found out, in painful fashion in some instances, with regard to previous efforts to bring enforcement actions against the tenant farmer, Mr. Russell, not with regard to this side of the property, but with regard to his operation on the other side of the property, which is something that's been a subject of complaints to the town for many years. And the zoning enforcement officer did give you, I don't know that she explained it to you fully, but I think she did tell you that Mr. Russell had been brought in under enforcement actions into the town justice court. They had they'd issued tickets to him. But the problem, and then she said that the town would have to go to Supreme Court to stop him. And that's true, because the justice court doesn't have the authority to order Mr. Russell to abate the violations. They can only issue fines to him or put him in jail, which they don't typically do on land use actions. So the town would have to go to court. Only a Supreme Court judge would have the authority to be able to issue an order, an injunction, which would be required to stop Mr. Russell's violations on his side of the property. But the Agriculture and Markets Law, just let me finish if I can. The Agriculture and Markets Law relaxes zoning restrictions, regulations in many ways as they apply to farming operations. And so that's an added complication here, because as unsightly as they are, most of the things that are out in that field, appear to be, agriculture related. So anyway, I'm sorry to cut you off, but that's
I hardly think buses are agriculture. I hardly think mattresses are agriculture. I highly think that debris as a dumping ground is agriculture. And I would like to know the difference between agricultural equipment and hoarding, because that equipment doesn't work. And getting to your initial point where you said if you went to the court, they look at a variance on what is existing and what they are requesting, okay? I would continue to argue that by allowing this footprint to increase You are increasing the problem of somebody that you can't contain in the town.
Well, I understand that that's your view. I don't agree with you that it provides a nexus to attach a condition to the area.
Okay, so then, let me ask you respectfully, would you like to live down the road from that?
That's not the point. That's
No,
not the
that
question.
is the point.
That's not the question that's before the board.
Yeah, and what we're...
Okay,
what we're-
so then, what I'm really hearing is that the variance could occur given what's happening there right now, given that this tenant farmer is a problem, and that the adjacent homeowners and neighborhood don't really have much to say about it. Because I have not rallied anyone. This is just me because I think it's so outrageous.
Well,
And it's just expanding.
It's not an issue that can be addressed within the context of this area variance application. That is what you're hearing.
So can the ZBA, do they have the authority to bounce it back to planning board?
No. This is an independent, this is a self-contained review.
John, what was Mr. Russell fined for?
I'm not, I don't want to speak to it because it's some time since I've had anything to do with those cases. But I do know some enforcement actions, more than one was brought. With regard to the farm that is on the north side of 308, not the piece of property that is being described in connection with this application.
These pictures that you took, they look much better than going there in person. I mean, this looks like,
Because
okay,
it's
it's old,
green now.
it's old farm equipment, and
It's
it's like,
green.
it looks almost poetic in a way. I mean, I just want to say one thing about a 10-foot fence. Talk about a gateway to a community. That is not the answer.
No, historic Rhinebeck, 1637, 1,000 feet. So who do I address it to? I go to the planning board brings me ZBA, ZBA says, go back and talk to the enforcement.
Look, John, it's a policing issue. I mean,
Well, first of all, with regard to, I understand that you are unhappy with the state of the property that's depicted in the photos. The issue, the underlying issue for the zoning enforcement officer, the reason that you were referred back to the zoning enforcement officer was to ask the question of the CEO whether any of the activities that are taking place on the part of Mr. Russell on that portion of the property is violating the town of Rhinebeck zoning law. That's what the jurisdiction of the zoning enforcement officer is. And if Michelle were to say, yes, there's a violation, the zoning board of appeals is not authorized to, and neither is the planning board, to prosecute violations of the zoning law. That's the zoning enforcement officer is the sort of zoning police officer for the town. So the reason that you were sent there was not to try to dismiss you. Instead, it was, this board can't undertake an investigation of whether what Mr. Russell is doing on Mr. Baker's property violates the law or not. But the zoning enforcement officer does have that capability. So you were asked to talk to Michelle about that in that regard. And I don't know whether what's happening there is violating the law or not.
But assuming it was, and I don't want to prolong this, but assuming it was, because this is obviously a very valid concern.
I'm sorry, I can't hear you.
I said this is a very valid concern, but assuming that there was a violation that was that could be prosecuted, what is the? And I'm just saying, I don't know. What is the mechanism? Does the CEO do it? Is there?
Well, it's to make
bring an action.
The way that go ahead. Sorry, Ed, if you know more about this.
I visited that site at least 4 times, other town board members, and we've issued violations, CEO has issued violations, I'm sure he's paid the fines, but in order to stop him, he has to take him to court.
But the visits that the town board has taken regard the activities that are on the north
Yes,
side of
yes,
308.
debris and everything
Okay.
up there. I've been up there 3 times. And I've asked him personally, he just doesn't care.
Yeah.
So,
And I will say that.
but the next step is, all right, you've issued these violations, enforcing them, I mean, where do you enforce them? Do you enforce them in the justice court? If you can't do that, do you have to bring a Supreme Court action?
That's it.
And if that's what you have to do, then it's the town who's gonna have to do that. And presumably the town attorney.
Yes. So with the just so that you understand, that a Supreme Court action can be an expensive endeavor for the town.
Respectfully, people's homes are expensive investments.
I'm not trying to argue with you.
No, I'm not,
Okay,
but
I'm
I
just
would
trying to
just-
explain.
We're trying to give you an
that
idea where to go
I don't
next.
want
I
this.
understand it's expensive, that's why I'm suggesting a fence is a very happy medium with not a lot of expense attached to it. That was my suggestion. I thought it was reasonable because of that. That was,
I understand that, I understand that, but you understand that that this board has a duty to act within its jurisdiction. And we have a duty to listen to the public and to take those comments into consideration and to try to address the concerns that those comments raise. But the board also has a duty to applicants to stay within their
I
jurisdiction.
I agree. I did not once say that Mr. Baker should not get his variance. I opened by saying he should get his variance. And if you want to bring it down to a variance point of view, that 2-garage overhead pole barn will not house that equipment that is on that field. It won't house it.
Well, I don't think it's been represented that that's where the equipment is going to go.
I think it was saying it was going to be his, Mr. Baker's tractor,
His personal
track,
equipment.
once he
Whatever-
started farming.
Whatever.
And so,
Whatever that
listen,
is.
this is why, and Mr. Baker has not come to one meeting that I could look at him and ask him that question. I'm not hiding.
Yeah, well, he's not required to come to the meetings if he's represented, so.
I understand.
I'm sorry that you're frustrated, but it's, the board has to, we adjudicate many applications. And as you saw from the Red Wing application, many applications where there's lots of concern and lots of strong feeling about it. And the board has to act in a manner that's consistent so that every applicant is treated the same.
Well, in my opinion, that end of Rhinebeck will become the orphan between the mine and that, okay? And I respectfully, the question is, who would want to drive past that every day to
I'm
go
not
into your
disagreeing
home?
with you that it doesn't look great, but that's not really the question.
No, the question
But
is,
the
the
ZBA.
variance, he's going to live there and the footprint is going to increase. And I'm not
Yeah.
being disrespectful. That's what's going to happen. And it's going to follow. If the footprint increases, the stuff increases.
Well,
Because he hopes to farm.
Well, there's where we disagree.
yeah, and that's not necessarily so. If you live there, perhaps you'll clean it up. And he's not living there, and if he lives there, the problem is we are not the enforcement agency. You're going to have to go to the CEO. They're going to have to, violations are going to have to be written up.
Well,
The
it
town is-
has to be established yet,
Yeah.
whether the presence of that equipment, as unsightly as it is, whether it is violating the zoning law.
Or the mattresses and all the rest of the stuff. But that's not our
Stuff
job.
that doesn't, excuse me, if something doesn't work and it's junk and it's towed from one place to another, what is the difference? So you're zoning board, so zoning. What is the difference between agricultural, collection and hoarding?
Well, I don't have anything more to really say.
I don't either, other than we're not it, and I think we've given you a little bit of direction of where you may be able to go in the future to try to remedy this.
Can I ask you one question, John? If a piece of property has a zoning violation, can the ZBA take up any matters concerning that property?
The ZBA's role in a violation is exactly, the Red Wing case is an example of where the ZBA's role comes in. So if the zoning enforcement officer goes, as they did to Red Wing, and they serve a notice of violation on the property owner, then the place to appeal that, if you're the landowner and you don't think that you think the zoning enforcement officer is making a mistake and that there isn't a violation, then your place to appeal first is to bring your case to the zoning board of appeals. And then the ZBA takes a look at the notice of violation and gathers information about the facts, and then you make a decision about whether you think the zoning enforcement officer was correct or not.
So if the zoning officer gave a violation, the appeal would be to hear.
Yes.
And that could be a whole separate issue of the variance.
Well, there would often, in this particular case, yes, that would be correct. And that's the question that Lisa's raising that I don't know the answer to, or what she's alluding to is, I don't know whether the material that's on that piece of property in the condition that it is and what it is, I don't know whether it is a violation of the zoning law. But it's the zoning enforcement officer's job to make those determinations, either in response to a complaint, or they can do that, if they observe a violation, they can initiate enforcement on it.
I would just like to leave with one parting thought and question. There's some magnificent farms on 308. And I'd like to know if everybody took that lead where zoning would go to, what it would look like. And that's my parting question, because you're setting a precedent now. And I know you're saying it's not you. Increase the footprint, increase the mass, and you know what? The farmer down the road who works so hard to keep his farm looking the way it does, guess what? That's ag equipment. It could be a dump truck that's broken down. It's ag equipment. It's setting a precedent. That's my opinion.
Yes, I don't agree with your opinion. I understand what your concern is, and I think that your concern is legitimate. And if I were in your shoes, I may be unhappy in the way that you are. But I've been doing this for 35 years. I've done a lot of work on all over the lower Hudson Valley and southeastern New York State. And I've seen lots of situations with farms, and the protection that farms get under the Agriculture and Markets Law, these problems are actually not uncommon. And we're lucky in Rhinebeck that a lot of the farms are quite nifty looking and well kept, but there are lots and lots of farmers get lots of relaxed treatment, even under state law. They can fill in wetlands, they can do lots of things that ordinary businesses are not able to do. And the Department of Agriculture and Markets is pretty aggressive in defending farmers with regards to those issues. And municipalities do the best they can to try to sync their zoning laws with ag and markets jurisdiction. I don't know what else I can tell you other than to say thank you to you for coming out and making your concerns known, and I can assure you I understand where you're coming from, and it gives me no pleasure to be delivering my opinion on this, but I'm bound to give the board my best advice as a lawyer about where this is legal.
Could I just ask one clarifying question, John, before you leave, Lisa? I just want to make sure that I understood all of that conversation. That because of the nature of the variances that we're being asked to consider,
yes,
there's no relationship to the issue of what's being stored on the property.
Very little relationship, in my opinion.
And that's why you're saying we don't really have a kind of leg to stand on. Because of the nature of what he's asking.
We took Lisa's comments very seriously, and after the comments were made at the public hearing. Kim and I met, and we went and did some research, and we looked into the cases with regard to the nexus between conditions that are placed on area variance approvals and the conditions. And there's lots of litigation out there, but the rules are very clear that there has to be a the courts are going to look for a substantial nexus in between the condition that's imposed. And you have to remember that first of all, the fence raises some other issues, because the height of the fence, if it's going to be more than 6 feet, is going to require another area variance and maybe site plan approval. You also know that we have had some cases that have come in front of you where people have been very upset about fences. And so that's a whole other thing. But the fence of the kind that's being suggested by Lisa is a fence that would also be quite expensive because of the size of the area that would have to be enclosed. And that's another issue that the courts would look at in terms of what the level of burden that is placed on the applicant as a result of the condition versus the area variances that are being sought. So we actually did quite a bit of thinking about this issue to make sure that it was addressed in the right way. But
What about devaluation of property?
I don't know what that means.
That's what I said. Who's going to buy homes with that stuff around it?
So the board is required to do a balancing test by state law, and the balancing test has 5 factors that are prescribed by state law, and that's the box that the decision is made in, and it has to be made in under the law. And that's not a factor that's considered. I'm sorry.
Well, that's what I meant about asking. The factors we are considering are the pole barn we don't consider because it's an ag building and it's actually going to be screened from other properties anyway. We consider whether the new house is going to be problematic and whether the house that's being moved is problematic. And neither of those are the issues that you're concerned with.
Now, I understand.
Yeah. So that, I was just trying to clarify for myself this as well as you.
It slipped. This slipped, in my opinion. Between planning and zoning, this slipped. That's my opinion. And it's nothing, listen, you folks, I wish you never to drive by that. And it's being not only contained, it's growing. Thank you.
Thank you. Thank you. Questions, concerns? Okay,
Scott,
what's that?
Scott, I have a resolution
Right.
which reflects exactly what John and Kim were
Right.
talking about. But it isn't reflected in detail in the resolution in terms of what happened there.
Well, all I'm going to do right now is, since this was a continuation, is to close the public hearing. And we don't have to do a resolution tonight, especially if you feel like you would like to amend it in some fashion.
Just add a little more discussion.
We can put it off to the next meeting, that is not a problem.
Well, you
Because of
feel
disclosure.
strongly about that, Tim? Because I think Kim and I talked about that. I think the question is sufficiently addressed in the resolution.
Oh, I think so too.
Yeah.
And I'm perfectly happy to.
Yeah.
It's up to you.
I mean, I wanted to provide, I know that Lisa put a lot of effort into the comments that she made in coming out. I wanted to clarify for her, if I could, some of the things that she was told by the zoning enforcement officer, and also to try to add some depth to the explanation. You know, it's not something that information or knowledge that people encounter all the time, so I just wanted to explain so that she had a better understanding of how the board is compelled to operate in these circumstances. But I think the resolution is sufficient. I think Kim agrees.
Yeah, and we made sure in the resolution because I know that this was a topic of discussion at the last meeting with Ms. Kusa and with the board afterwards. So I did try to include, statements concerning the condition of the property and the representations that have been made by Mr. Baker himself about the intention of cleaning it.
Yeah, no, I think the language is complete. It's just that, I think we can add a sentence.
I have the fan right in my ear. I can't hear you too well. You just speak.
I think we can just add a sentence that the public hearing carried on through a month and closed on, because right now it's written as if.
I think I have something that it was continued and closed, but.
Yeah, but
we'll
we
make
can
sure.
add
We'll make
something
sure.
and provide that to Chris for the last,
Right.
to add to the final version of
Do
the
you want me to-
resolution.
Do you want me to read the
All right, well, first I
Let's
have to-
close
I-
the
I-
public
I-
hearing.
Yeah, that's what I was gonna do, I was gonna close the public hearing, so.
Was it, you made a motion to close, was it?
I was just about to.
Oh, okay.
So let me make the motion. At this time, I make a motion to close the public hearing. Do I have a second? Second. Okay. All in favor? Aye. Opposed? Abstentions? Okay, the public hearing is closed.
Okay. Resolution of the Town of Rhinebeck Zoning Board of Appeals in the matter of the area variance application of Jeffrey Baker, ZBA case number 1015. Whereas, paragraph 1, or section 1, background, applicant. The applicant is Jeffrey Baker, referred to hereinafter as the applicant. The applicant was represented at the ZBA by Matt Town, PE of Willingham Engineering. 2, property involved. This appeal involves property located at 1010, 1014, Route 308 in the town of Rhinebeck, and which bears the tax parcel number 6371-00-426548. The applicant's property is 24.5 acres in area and is located in the RC5 zoning district. Property is also located in the New York State Agricultural District. Number 20. 3, description of proposed project. The applicant seeks to construct a new 2-bedroom, single-family home on the property. There is currently an existing 2-bedroom, single-family home on the property, which is to be relocated to a northern portion of the property to be used as an accessory dwelling unit. The new single-family home will be built in the same location where the existing 2-bedroom, single-family home is currently located. As a result, the new single-family home will be located further back from the fronting street than the relocated accessory dwelling unit. Thus, the accessory dwelling will be closer to the fronting street than the principal structure. A pole barn is also to be built, however, the determination letter from the CEO, the acting CEO, has noted to the CBA the pole barn is an agricultural building and thus is not part of the CBA's review. In addition to the current single-family dwelling, there is also a non-conforming garage that will remain in its present location within the side yard setback, and a non-conforming agricultural shed within the front yard setback. Similar to the pole barn, the ZBA has been advised by the acting CEO that these structures are not part of the ZBA's review as they are existing non-conforming structures. In total, 2 area variances are requested. 1, zoning law, section 125-27A3, with the exception of agricultural structures, guest cottages or caretakers, dwellings, with the exception of agricultural structures, guest cottages or caretakers dwellings, accessory structures shall not either project closer to the front street rather than to... Would somebody else like to read this? I don't feel like my synapses don't seem to be connected.
I'll read it, okay.
Do you have the updated one, Scott? Are you following him? Because I seem not to have
I don't think I have.
exactly what he's reading.
I don't have it.
I don't have the latest copy.
Do you have?
I wasn't.
So this is where Tim left off.
Right, yeah, right, okay.
Okay, that's good.
Well, this is different than,
Okay, I think,
We had emailed it to the board, so I don't know. I thought maybe Chris wasn't on that. I
I
thought
don't
you were.
know.
Do you want to, can you make a copy?
wow, it's right in the
I
room.
know.
Amazing.
COVID, something good came out of it. That was a good one.
It's the one that you sent on 7th.
Because I had provided legal advice in there.
That's great.
I didn't want to get confused.
Yeah, you should be able to pick it if there's a problem.
What?
So if there's a problem, you let us know as far as picking up our voices and all that. Kind of
Well, I
stuff.
mean, I have it up all the way. Some parts where it goes a little low, I can hear almost everything. But some part, your voice is a little bit low when you're just reading them.
But
You
these
turn it up
mics-
all the way.
These mics actually work if you talk into them.
Yeah,
Right? You press the button.
I can understand pretty much everything.
So you can hear me well like this.
I can hear you. Still hearing the fax machine a little bit though. I mean, the copy machine.
I mean, the problem is I have a problem.
They're you and they're talking that way.
Yeah.
So,
You'll have to listen. You're with it.
We'll just keep our voices up and project. Yeah.
because it's so
I should probably actually ask that.
It's very important.
I did.
Okay, oops. Well, we're good. Everybody's got a copy. I'm just gonna.
Thanks, Chris.
So we're just making copies for the rest of the town. All right, so I'll pick it up here. This is under paragraph 3.1. Zoning law section 125-27A3, with the exception of agricultural structures, guest cottages, or caretaker dwelling, accessory structures shall not either project closer to the fronting street than the principal building or be located within a required front yard. The relocated accessory dwelling unit will be closer to the fronting street, State Route 308, than the new single-family dwelling, and thus a variance is required. 2, zoning law, this is the second variance, zoning law section 125-27A4. Roofed or otherwise enclosed accessory structures, except for agricultural buildings, shall in the aggregate comprise not more than 1,500 square feet of floor area. The maximum allowed aggregate floor area in the zoning law, 1,500 square feet. The applicant proposes an aggregate floor area of 2,520 square feet, which is comprised of the attached garage, 1,080 square feet. The detached garage, 560 square feet. The two-bedroom accessory dwelling unit, 880 square feet. Hence, the total variance required for the aggregate floor area for roofed or otherwise enclosed accessory structures is 1,020 square feet. Section 2 ZBA review, paragraph 4. Timeliness of the appeal. The applicant filed an appeal with this board on May 3, 2021, and has paid the requisite fee. The appeal was filed within 60 days of the date of the acting CEO's determination letter appealed from, dated April 26, 2021, and thus the application is timely as required by Section 125-125B of the Town of Rhinebeck zoning law. The application was deemed complete and accepted by this board on May 19, 2021. 5. Referrals and responses. The application was referred to the Town of Rhinebeck Planning Board on May 26, 2021. We received their response on June 9, 2021, noting no significant planning or environmental issues. 3. Seeker. On May 3, 2021, the Town of Rhinebeck Planning Board determined that this matter should be classified as a Type 2 action under the State Environmental Quality Review Act, secret. The ZBA accepts this classification. No further review is required pursuant to secret. 7. Site visit. ZBA members Tim Allenbrook and Catherine Clark visited the applicant's property on June 8, 2021. Anybody else have a visit out there? All right. No business or deliberations were conducted during the site visit. The purpose of the visit was to observe firsthand on-site conditions, property characteristics, setting, surrounding environment, and the character of the surrounding neighborhood. The property is wooded, field, and lakefront. Neighboring structures are difficult to see. There are various deteriorated pieces of farm equipment scattered about the fields abutting Route 308. Such condition had been brought to the ZBA's attention during the public hearing by photos and testimony provided by Lisa Kusa, a neighbor to the property. The photos depict horse trailers, farm equipment, and vehicles, temporary sheds, a corral, and other miscellaneous equipment located on the applicant's property. 8. Public hearing. A public hearing on this appeal was duly advertised and held on June 16, 2021. Because of the COVID-19 pandemic, the public hearing was held virtually pursuant to New York State Executive Order 202.1, which suspended certain provisions of the Open Meetings Law to allow a municipal board to convene meetings during the current pandemic via video conferencing and or telephone conferencing. The public was thus afforded the opportunity to view and participate during this public hearing remotely. During the course of the public hearings, we heard comments and received various letters from Lisa Kusa of 6 Daisy Lane, who is concerned with the farm equipment, vehicles, and other materials on the applicant's property and in the fields across the applicant's property. In response to Ms. Kusa's comments, the applicant provided an email to the ZBA dated June 15, 2021, which stated to the ZBA that the pole barn would be used for the applicant's personal tractor and farm equipment. The applicant also stated that he planned to take over all farming activity on the property once he moved to the property, and that he planned to take over the farming and the current tenant farmer would not work the field. The applicant further noted that all of the tenant farmer's equipment would be removed. The ZBA is appreciative of the applicant's statement that the current tenant farmer's farm equipment, vehicles, and other materials will be removed once the applicant starts living on the property and farming himself. During the public hearing, the ZBA requested additional renderings of the pole barn and full floor plan of the single-family home, including attached garage. These documents were submitted to the ZBA on June 28, 2021. The public hearing was held open to allow for the review of those submitted documents. The public hearing was closed on July 21, 2021. Findings of fact and conclusions of law. Paragraph 9, balancing test. In our review of the various variances sought, we have considered the benefit to the applicant if the area variances are granted as weighed against the detriment to the health, safety, and welfare of the neighborhood or community by such grant. We determined that the variances requested should be granted because there is minimal detriment to the health, safety, and welfare of the neighborhood or community by the granting of these variances. 10. Consideration of the 5 factors balancing test. In our determination, we have considered the 5 factors required by Section 125-124C1 of the Town of Rhinebeck zoning law as follows. A. If the variances are granted, will they cause an undesirable change in the character of the neighborhood or causing detriment to nearby properties? We find that the answer to this question is no. The ZBA is aware of the concerns that have been raised about the condition of the property with the farm equipment, vehicles, and other materials from the current tenant farmer. While the ZBA understands the concerns voiced about the unsightly condition of the tenant farmer's farm equipment, vehicles, and other materials, and while the ZBA agrees that this material is unsightly, those materials are not within the ZBA's jurisdiction in this matter. The ZBA must conduct the balancing test as it applies to the area variance sought, which in this case are for the siting of the single-family home and the aggregate floor area of the accessory structures. The property, at nearly 25 acres, can easily accommodate structures located as proposed with minimal impact on the neighborhood or adjacent properties. Much of the property, including areas where the structures will be sited, will not be visible from Route 308. B. Can the benefits sought by the applicant be achieved by some method feasible by the applicant to pursue other than an area variance? We find the answer to the question is no. The rear of the property is within a wetland buffer, and the structures have already been carefully placed to be outside the wetland buffer to avoid any wetland disturbance. The benefit being sought is a lakefront location, and thus the applicant has requested the single-family home be located as close to the lake without disrupting the wetland buffer area. In order to achieve that view while maintaining the distance outside the wetland buffer area, an area variance will be required. C. Is the area variance substantial? We find that the answer to this question is no. Given the large size of the property, these variances are reasonably inconsequential in terms of setback from the frontage road and overall build-out allowed. D. Will the proposed variances have an adverse impact on physical or environmental conditions in the neighborhood or district? We find that the answer to this question is no. We find no adverse impact to the physical or environmental conditions of the property if the area variances are granted. The applicant is taking appropriate steps to mitigate the proposed structure's impact on adjacent properties in proximity to the lakefront by utilizing existing topography and woodlands. E. Is the alleged difficulty self-created? We find that the answer to the question is yes. The need for these variances is due to the applicant's desire to site the proposed structure on the lakefront. The applicant could forego relocating the accessory dwelling unit and remove the structure entirely. This would eliminate the need for at least one of the variances sought. 11. Minimal variance requested. In addition to our review of the 5 factors and balancing test, we must also determine if this requested, if these, I think that's the English version, if these requested variances are the minimum necessary and adequate to accomplish what is requested by the applicant. We find that the answer to the question is yes. Given the topography and wetland zones of the property, there is only one logical area along the lakefront to site the proposed structure without significantly impacting wetlands. Therefore, the variances requested are the minimum required to achieve when it's requested. Now therefore be it resolved based on all of the facts described above and upon the reason described above as follows. Section 1. The ZBA grants the 2 variances requested by the applicant, finding that the benefit to the applicant outweighs any detriment to the health, safety, and welfare of the neighborhood or community by such a grant. Zoning law section 125-1-27A3 requires accessory structures not to project closer to the fronting street than the principal dwelling. Therefore, an area variance is granted for relocating of the accessory dwelling unit to be 135 feet in front of the principal dwelling. Zoning law, section 125-27.4, limits roofed or otherwise enclosed accessory structures to an aggregate of not more than 1,500 square foot of floor area. Therefore, an area variance of 1,020 square feet is granted to allow for a total of 2,520 square feet aggregate floor area for roofed or otherwise enclosed accessory structures. Section 2, the granting of these variances will be expressly contingent upon the applicant's full payment to the town of Rhinebeck of any and all fees and escrow deposits due in connection with this application in full compliance with Article 4 fee reimbursement of the town of Rhinebeck zoning law. These variances shall not be deemed granted until all such fees are paid in full by the applicant. Section 3, the granting of these variances does not absolve the applicant from having to secure any other required permits and/or approvals. The proposed structures must be constructed in conformity with the application and plans submitted. Section 4, these area variances shall be null and void unless the proposed construction is commenced within 1 year of the resolution. Okay, any comments or?
Yeah, I do.
Okay.
In ZBA review, number 8 public hearing, the applicant also stated that he planned to take over all farm activity on the property. It doesn't sound like that from, that he hopes to, is that correct? From his email?
So you're saying this is more definitive than what he said?
Yeah, than what he was saying.
Right.
I like it being more definitive.
Yeah, but what did he say? We're recounting what he said, right?
Yeah.
We did, we actually, I'll let Kim can answer this, if you have you would refer to, but, so we wanted to make sure that exactly what Mr. Baker represented made its way into the board's findings so that it would be clear that that representation was a basis for the board's, was part of the basis for the board's decision, even though that couldn't be that couldn't be attached as a condition. It still was something that was influential to the board.
No,
in
but
making
what I'm
the
saying
decision.
is that, I'm sorry, I forgot your name.
Matt.
He just read the email, and he was saying he hopes to take over the farming, correct?
That was
Yeah, that's quite different than saying
He will.
he will.
Wait, it says he plans to.
I'm sorry.
We didn't say, he said that the email represented that he plans to take over.
Okay. I
Well,
thought he just read that he
Well,
hopes to take it
This
over.
is what the,
Can we read it again?
yeah,
Why-
this is, the email says, this was the response to Ms. Crusoe. It says, "The pole barn will be behind my home and is for my personal tractor and farm equipment that I currently own and the house at my current residence. I hope to take over farming activity on my property when I move to the property. Once I take over the farming, I will have no need for the current tenant farmer and all of his equipment will be removed."
So it's a difference between hoped and planned.
They were both there.
It's a semantic game.
Yes.
By the way, that's part of the record, right?
Yes. Yes.
That email is part
Yes,
of the record.
because it was sent to
Good.
Chris.
I mean,
Okay.
if we put the emphasis on the second or third sentence in that, when I take over the farming, then there will be no need for this. Or you put the emphasis on the hope, in which I think it's a different consideration, at least from my perspective.
I mean,
So
I think
the resolution is
we,
written to put the emphasis
we
on
could
the second
change it
part.
if, I understand what Tim's comment is. I think that the way that we were looking at it is that the applicant intended to give the board, the impression that he intends to take over the farming of this. And the decision was written to show that that was significant to the board and that the part of the reason we're making the decision, one of the things that's in the recipe for coming out with this decision is the board's, there's a section of the decision that the board appreciated that he made that statement and that that's part and parcel of the decision, even if it's not being made a condition.
But instead of saying plan, why not just parrot exactly what he said in his email?
You can do that if you want.
I think that's probably more accurate. And that would make you feel more comfortable.
Yeah, I think so.
Okay, well, what we can do is, on a revised
Yeah.
version of the resolution, we can just, we'll put
You
a
can
block
just put a
block
quote,
quote.
yeah.
Put a block quote of what he did, what he said. It's part of the record, and I agree that hoped and planned are maybe different things. Planned
Understood.
seems to be more concrete.
Feet. Yeah, I don't know how to spell that, but.
Point well taken. Any other questions?
There's a two overs on that. He planned to take over the farming over.
Oh, well, we're gonna put a block quote, so,
Oh, okay.
You're going to put it inside.
yes.
Yeah.
And Chris, you got that one little English,
This, thus,
Glitch.
something like this, these.
these, that,
these,
those.
Section.
Yeah.
Make it-
I'll
make it
fix that
English.
one when I do
All
that.
right, no worries, thank you.
Tim, did you want to add anything about comments made during tonight's meeting?
I don't think it's really necessary because.
It's the same, we had mentioned that Ms. Kuza's
Well, maybe you
comments-
could say something like, as she reiterated these same concerns at the hearing. I think that,
Okay,
because,
yeah.
We can do.
so I'd like to give her credit. She was here, she was
Yep.
passionate and made good points, and so she, I think she said it twice. Any other questions, concerns? Okay.
Hold the barn, all right, stop.
So the motion is to
Oh, okay, so the
adopt,
motion-
is to motion,
I gotta have
is to
myself.
adopt the resolution as
Right.
amended by the discussion.
That is exactly the motion. I adopt what the learned counsel to my left has just said. I did like that.
I like it a lot.
Do you have a second?
Second.
See if anyone else likes it.
Now you may poll.
All right, got you. Scott Burgett.
Yes.
Kathy Clark.
Yes, with the consideration, I mean, I feel like he's made a commitment to, whether he wants it or not.
Tim Econopoulos.
Yes.
Tim Allenbrook.
Yes.
Oh. Richard, and I was going to say Kopazinski, but you actually said it differently.
Good enough. Yes.
Kopacz.
Kopashansky.
Kopacz.
Ah, got you twice.
2 in a row.
Phonetics. All right. And the last thing we have is we have.
Thank you. The amended version of the resolution, thank you, Chris, will be available from Chris the next day or two.
Okay, great, thanks a
All
lot.
right,
everyone.
Thank
Thank you for your time.
Thanks for calling
Thank
out.
you, Matt.
Thank you.
Catherine, I believe you're next.
I am.
And last,
I
but
am.
certainly not least.
I hope
No, never.
not. Resolution of the Town of Rhinebeck Zoning Board of Appeals in the matter of the area variance application of Hannah Barrett and Laurel Sparks, ZBA case number 1006-A. Background. The applicants are Hannah Barrett and Laurel Sparks, hereinafter the applicants. The applicants are seeking 2 area variances to locate an accessory structure, a 24-foot by 26-foot shed workshop on the property. The applicants were previously before the ZBA in late 2020 for a variance for the side yard setback for a similar shed, which was granted in December 2020. See ZBA case number 1006. The subject application and request for variances results from the determination letter from the acting Town of Rhinebeck zoning enforcement officer dated April 22, 2021, which stated that the town zoning law requires that accessory structures be no closer than 150 feet from the front boundary and 45 feet from the rear boundary. The applicants have slightly adjusted the structure size from the previous application, but it will be located in the same general location. The proposed shed would be 86 feet 3 inches from the front boundary, requiring a variance of 63 feet 9 inches, and 37 feet from the rear yard boundary, requiring a variance of 8 feet. Thus, additional variances are required for the siting of the accessory structure. The accessory structure does not require any additional variances for the side yard setback that was already granted. Property involved. The appeal involves property located at 317 Mill Road, Rhinebeck, New York, which bears the tax parcel number 1350896069004000000. The applicant's property is approximately 0.74 acres in size and is located in the RA10 zoning district. Representation. The applicants are represented by Ms. Barrett. Description of proposed project. The applicant seeks to erect a 24-foot by 26-foot shed workshop that will be 37 feet from the rear property line and 86 feet 3 inches from the front property line. This structure already received a side yard setback variance for 17 feet from the side boundary. Number of variances required. 2 variances are requested to supplement the side yard setback that was previously granted in December 2020. Variance 1. The Town of Rhinebeck zoning law, section 12527A2, requires a front yard setback of 150 feet for accessory structures. The proposed setback will be 86 feet 3 inches, requiring a variance of 63 feet 9 inches. Variance 2, the Town of Rhinebeck zoning law 12527A2 requires a rear yard setback of 45 feet for accessory structures. The proposed setback will be 37 feet, requiring a variance of 8 feet. Timeliness appeal. On April 22nd, 2021, the acting ZEO determined that 2 area variances were required in addition to the previous variance granted because the accessory structure was closer to the front and rear yard than required under zoning law 12727A2. The applicant filed an appeal for area variances with this board on April 29, 2021, and has paid the requisite fee. The appeal was filed within 60 days of the ZEO's determination, and thus the application is timely as required under section 125B of the Town of Rhinebeck zoning law. Acceptance of application is complete. The applicants provided the ZBA with a presentation on May 19, 2021, on which date the ZBA deemed the application complete. SECRA and Planning Board approval. This application was simultaneously before the Town Planning Board for a special use permit and site plan approval. On November 16, 2020, the Planning Board classified this action as a Type 2 action. The ZBA accepts the Planning Board's classification from November, and no further environmental review is required pursuant to SECRA. Referrals and responses. The application was referred to the Town of Rhinebeck Planning Board, and they responded on June 9, 2021, with the findings that the requested variance raised no significant planning concerns and recommended that the ZBA rely on its own study of the facts. The application was also referred to the Waterfront Advisory Committee by the ZBA following the May 19, 2021 meeting. The WAC subsequently responded via updated memo stating that WAC member Joe Capia had visited previously the subject property on November 6, 2020 and reviewed the minor changes that were presented to the zoning board. The WAC noted that the changes will have no material impact to the previous analysis. The WAC found that the property is located in the local waterfront revitalization program, but that the property is not in the 100-year floodplain nor located near any federal or DEC wetlands, and that no areas of historical or archaeological significance will be impacted by this project. The WAC also noted that the property is located on a state-designated road, Mill Road, but the building site would be mostly concealed from view. The WAC further noted that the project site for the structure is located in the only flat buildable area left on the site, excluding the house. Overall, the WAC found no impact from the project. Site visit. As stated above, the applicants were previously before this board in late 2020 for the siting of this accessory structure. During that initial application, ZBA members Catherine Clark and Scott Bergen on November 11th, 2020, and then ZBA member Dave Tobias on December 5th, 2020, had visited the applicant's property and the surrounding neighborhood to observe firsthand on-site conditions, property characteristics, setting, surrounding environment, and the character of the surrounding neighborhood. Given that there was no material change in the project for this supplemental application, the follow-up visit was deemed unnecessary. Public hearing. A public hearing on this appeal was duly advertised and held on June 16, 2021. Because of the COVID pandemic, the public hearing was held virtually pursuant to New York State Executive Order 202.1, which suspended certain provisions of the open meetings law to allow a municipal board to convene meetings during the current pandemic via video conferencing and/or telephone conferencing. The public was afforded the opportunity to view and participate during this public hearing. No comments were received from the public for the application, and the public hearing was closed on June 16, 2021. Balancing test. In our review of the variances sought, we have considered the benefit to the applicants if the area variances are granted as weighed against any detriment to the health, safety, and welfare of the neighborhood or community by such grant. We have determined that the variances requested should be granted because there is no detriment to the health, safety, and welfare of the neighborhood or community by the granting of the variances. Consideration of 5 factors in balance test. In our determination, we have considered the 5 factors required by Section 125.124C1 of the Town of Rhinebeck zoning law. If the variances are granted, will they cause an undesirable change in the character of the neighborhood or cause a detriment to nearby properties? We find the answer to the question is no. The shed will be visible from Mill Road, but its placement and design will be in keeping with the neighborhood and other structures in the area. Other nearby residential properties on the same side of Mill Road appear to have sheds. The size and design of the subject shed will be in keeping with the surrounding properties and structures and the nature of the neighborhood. The accessory structure will be painted the same color as the existing single-family house, thus helping the structure fit in with the character of the neighborhood. Can the benefit sought by the applicant be achieved by some other method feasible for the applicant to pursue other than these area variances? We find the answer to this question is no. The property is small enough that any placement of a shed is likely to require variances from local code and would likely be seen by neighbors and/or from Mill Road. As noted by the WAC, the property affords very little area where the structure could be placed. I guess that should be placed. A D added there, Chris.
Got it.
And this proposed site is the only flat buildable area left on the site where the accessory structure could be placed. The proposed location is as far from the road as possible given the topography. Are the requested area variances substantial? We find the answer to this question is no. Given the small lot size and limited available suitable locations due to topography, this is the best location for the shed. Although numerically the variances may seem substantial, the potential impact in granting these variances is not substantial because the shed is set as far back from the road as possible, and the matching color with the existing single-family home will help it fit in with the character of the neighborhood and the layout of the lot. Will the proposed variances have an adverse impact on physical or environmental conditions in the neighborhood or district? We find the answer to this question is no. While the shed will be visible from 1 or 2 neighboring lots in Mill Road, it is relatively small and unobtrusive. In addition, the land slopes down from the road, reducing visual impact from Mill Road. Is the alleged difficulty self-created? We find the answer to this question is yes. However, given the topography of the property, there is no other reasonable place to place the shed. Minimal variance is requested. In addition to the review of the 5 factors and balancing test, we must also determine if the requested variances are the minimum variances necessary and adequate to accomplish what is requested by the applicant. We find the answer to this question is yes. The proposed shed is not inappropriate or unexpected for properties that lack significant expansion areas within or surrounding the residences. It is noted that roughly half the nearby residential properties on the same side of Mill Road appear to have sheds, though most are in the backyards rather than side yards. However, given the limited available space on the lot and topography, the shed cannot reasonably be placed in the rear of this lot. Nevertheless, the size and design of the subject shed will be in keeping with the surrounding properties and structures and the nature of the neighborhood, and the new fence that was erected on the subject property will reduce, though not eliminate, visibility of the shed from Mill Road. The topography of the land precludes the placement elsewhere on the property. Result is a balancing test. Based on our analysis of the 5 factors we discussed above and the consideration of having the minimal variances requested, we find that the balancing test favors granting of the area variances sought. Now therefore be it resolved based on all the facts described above and upon the reasoning described above as follows. The ZBA hereby grants 2 variances as requested. A variance of 63 feet 9 inches from zoning law 1252782, which prohibits the location of an accessory structure closer to the front lot line than 150 feet, thus allowing the accessory structure to be located 86 feet 3 inches from the front lot line. A variance of 8 feet from zoning law 12527A2, which prohibits the location of an accessory structure closer to the rear lot line than 45 feet, thus allowing the accessory structure to be located 37 feet from the rear lot line. The benefit to the applicant outweighs any detriment to the health, safety, and welfare of the neighborhood or community by such a grant. The variances are supported by the balancing of the 5 factors as discussed above. Section 2, the granting of the variances is expressly contingent upon the applicant's full payment to the town of Rhinebeck of any and all fees and escrow deposits due in connection with this application in full compliance with Article 14 fee reimbursement of the town of Rhinebeck zoning law. These variances shall not be deemed granted until all such fees are paid in full by the applicant. Section 3, the granting of these variances does not absolve the applicant from having to secure any other required permits and approvals. Section 4, these variances shall be null and void unless construction pursuant to the plan is begun within 1 year of this resolution. The construction must be in conformity with the site plan, the renderings, the application, and all other information forwarded to the ZBA. Any discussion?
I had a question, Catherine. On paragraph 9, talking about the WAC, it says in the resolution I had via undated memo, but you guys said via updated. So is it supposed to be undated or updated? Both are true.
Updated.
Updated.
Is what I meant.
Okay. It was an updated memo, so that's why I just didn't.
Okay. No, that's good catch.
And then the last sentence on that same paragraph, we have the site is misspelled. So it says, WAC further noted that the project site for the structure is located in the only flat buildable area left on the site.
Oh, yes, on the site, not the sty.
Spell check on that one.
Well, sty is a word.
No, it's not spelled like that.
Well, it is now.
I guess so.
Those are my.
Is it in the Scrabble dictionary? Any other comments? Considerations? Should I make a motion?
Please do.
I make a motion to approve this resolution
With
as corrected, yes.
And I will second.
Thank you.
All right. Scott Bergen,
Yes.
Catherine Clark,
Yes.
Tim McAnapoli,
Yes.
Tim Allenbrook,
Yes.
Richard Kopuzinski.
Yes.
All right.
Done. That was nicely written resolution.
Kim.
And thanks to Hannah Barrett, who I think was very patient,
Very.
considering the route that this application ended up taking. So anyway, Hannah, if you're watching, thank you.
Yes,
We
absolutely.
appreciate that.
Very gracious. I might not have been if I was in her position. Anyway, welcome aboard, Richard. Made it through your first meeting, and I don't think we have anything else. Do we have anything else to
I don't
discuss?
think so.
All right, so we'll have a motion to adjourn. All in favor? Aye. And if you're opposed, you can stay.
Thank you,
And we'll
Richard.
see you in a month.
Thank you, everyone.